So hello, everybody. First of all, my thanks go to the organizers for their kind invitation to deliver a keynote lecture on the occasion of your conference on Benjamin's relevance for legal theory today. As the topic is one I've just spent considerable time thinking about while preparing my translation and critical edition with Peter Fenves of Benjamin's Toward the Critique of Violence, I want to focus my comments here on one of the overarching questions that guided our work on the essay and related writings, which of course was and continues to be one of the main sources of critical thinking on law in Benjamin's oeuvre. And the question is simply this: what does Benjamin mean by law? By way of answering this question, as well as demonstrating perhaps some of its importance for how we might want to work with Benjamin on law today, I'm going to set up some theses, following each of which I'm going to elaborate on some issues that arise from each of them. The first of these is this: law is not the law. For those who are familiar with the German language, you will of course already be aware of a peculiarity attached to the word that is translated as law in English. Namely, there are two words for law in German, Recht and Gesetz, which the English distinguishes typically by prefacing the translation of the latter with a definite article. Thus, Recht, or das Recht sometimes, refers to law in its indefinite sense, unattached to any particular institutionalization or act of instantiation thereof. It also provides the root of Gerechtigkeit, which is the word for justice. Justice is, etymologically considered, the administration of jus, which in the Latin refers to law or right. Inasmuch as law in its administered form is the root of justice, then law is also right. Administered correctly, which in German can also be expressed by a phrase utilizing the word Recht, law presumably makes justice manifest. Gesetz, by contrast, refers to the individual act of legislation or body of legislation, if we're talking especially about laws in the plural, the law, if you will. It is a modification of the verb setzen, which means positing or setting. Related are also terms like Satzung, meaning statute, and Entsetzung, which in its legal sense is equivalent to relief, as in to relieve someone of one's possession, power, or right. Last but not least, Setzen combines with Recht to form the term Rechtsetzung, which refers to the production of legal norms and generally binding orders. In short, lawmaking or legislation. All of these terms are deployed by Benjamin in one form or the other, particularly in the essay Toward the Critique of Violence. Perhaps most famously, the last term I mentioned, Rechtsetzung or lawmaking, becomes remade into the phrase rechtsetzende Gewalt, the violence or force that is attached, according to Benjamin, to the act of positing law. Indeed, Benjamin calls law positing a function as well as character of Gewalt. What this law is that is supposed to be the direct object of this positing, though, appears already in the very opening sentence of the essay, where Benjamin writes that, quote, the task of a critique of violence may be described as the presentation of its relation to law and justice. The and between Recht and Gerechtigkeit in this sentence does not conjoin them, however, as their etymologies might suggest they be. Rather, as the rest of the opening paragraph takes as clear and self-evident, the and is a disjunction, Recht or Gerechtigkeit, law or justice. In fact, the disjunction is so radical that Recht and Gerechtigkeit entail for Benjamin wholly differentiated spheres, namely that of justified means and that of just ends. Building on these spheres are also entire trends in legal philosophy, whose very elaboration serve to further entrench the separation of Recht from Gerechtigkeit by virtue of the questions or suspensions of questions, the Ausschaltung, that they avail themselves of. Benjamin names these trends natural law on the one hand and positive law on the other. The one trend, natural law, suspends the interrogation of the use of certain red violent means for the attainment of ends, since all that matters is whether the ends are just, while the other trend, positive law, concerns itself with the justification of means, independently of the question of ends. From the outset, for Benjamin, then, law and justice appear to be irreconcilable concepts. Law, however it might be administered, does not allow for the question of justice to be posed. Justice is not something that is per definition attainable via legal means. As he writes, natural law strives through the justness of ends to justify the means, and positive law strives to guarantee the justness of ends through the justification of the means. In this sentence, which is found in the third paragraph of the essay, what might otherwise appear as justice, namely Gerechtigkeit, is a function of law or Recht, inasmuch as positive law arrives at so-called justice through justification or Berechtigung, a process of rendering justifiable through law. Through law, then, justice decays into justness, that is, a quality that emerges from a legal process. Through law, too, we therefore arrive at law-sanctioned violence versus non-sanctioned violence. Through law, then, law decays into its historical opposite. Does this make Recht then closer to Gesetz, the individual act of legislation, of which Benjamin specifies that they are legal customs brought under the protection of archic power? This is in paragraph 9. Law, one might say, is not the law so much as law is and only ever has been the law, the legal customs brought under the fold of a power guaranteed by the assumption of its archic quality, the idea of an order that is fated with a monopoly on the right to decide what does and does not belong to law. This brings me to my second thesis, namely, natural law and positive law refer not to the same sense of law, but to wholly differentiated modes of legal status. Law is not the law so much as law is law, only ever as the law, that is, by the power of law's conviction in its own arche, its power of decision over what is or is not sanctioned in its name, what is or is not therefore law. Can we then still say that law per se exists? Insofar as law is radically disjoined from justice by virtue of the very question of what law is for, serving just ends or justifying the means, law is accordingly what it is in regard to the question and answer to the question, which is in turn posed by the two trends of legal philosophy named by Benjamin, natural law and positive law. Natural law, which Benjamin does not fully define in the essay, might best be understood in context of the legal tradition inherited by early 20th century German language legal theory. Generally understood as drawn from ancient Greek and Latin sources to denote a theory in which morality is understood as a feature of the cosmos, natural law is presumed to be discoverable by the light of reason. In the late 17th century, the doctrine to which natural law refers in the European public law emerged that would, by the mid-18th century, become known as natural constitutional law, or natürliches Staatsrecht. In the 19th century, a further terminological development occurred. Natural law became synonymous with the academic discipline of legal philosophy, and natural constitutional law split into two fields. On the one hand, the common constitutional law of the German states, or Gemeines deutsches Staatsrecht, which referred to existing legislation. And on the other hand, general theory of state, or allgemeine Staatslehre, which concerned itself with foundational questions instead. When, however, the interest in foundational questions began to wane in favor of the applicability of empirical methods to the dispensation of positive law, natural law became almost exclusively the purview of liberal jurists in whose view law and constitution were to be regarded as anything but self-evident objects of study. In other words, there inhered in natural law a revolutionary potential, one that the jurist Carl von Savigny, for instance, reacted against by proposing to replace it with the historical view on the provenance of positive law. In reaction to Savigny, in turn, there emerged, by the late 19th century, a collection of jurists and legal philosophers who insisted on discerning a purpose or end in law for which any reasonable person has a duty to struggle. This was a view particularly associated with Rudolf von Jhering, whose work Benjamin describes in a near contemporaneous fragment as important. Law, according to this major trend in the legal philosophy then, refers to the idea, newly revived in the context of the recently elapsed German Revolution of 1919, Benjamin's words, that the new German constitution should self-evidently conform to the ideals of justice that are themselves supposed to be self-evident in the sense of universally accessible to all educated and reasonable citizens. Positive law, by comparison, holds as legitimate that which has been posited regardless of its merits vis-a-vis natural givens, such as ideals of justice. One of the most prominent sources of legal positivism of Benjamin's time, Hans Kelsen, proposed a program to render law as a chain of a priori norms, whose meanings are conferred by other successively higher norms without reference to any other domain or ends, including and up to the highest norm, the Constitution. The legal validity of the first historical norm, Kelsen argued, must simply be presupposed. Another prominent source of legal positivism, Georg Jelinek, argued that the validity of law be derived from what he called the normative power of the factual, which is to say that according to him, the very fact that state power, Staatsgewalt, asserts itself in the formation of a constitution itself implies the recognition of this claim by the citizen recipients of these norms, which for him ought to be sufficient in themselves to legitimize the legal order in question. Such arguments as Jelinek's were thus the source of the distinction between historically recognized and non-recognized, or in other words, sanctioned and non-sanctioned violence. In his general theory of state, Jelinek goes on to argue that this sort of normative factual recognition helps clarify how it is that the open violence, offene Gewalt, often involved in the dissolution and formation of new states, such as in a revolutionary situation, can nevertheless transition into legitimate state power by means of a legal constitution, Staatsrecht, regardless of the merits of the constitution. That is to say, even if this new constitution is, for instance, exploitative or despotic. Thus, Benjamin writes, the standard by which positive law classifies its means as sanctioned or non-sanctioned violence can undergo only its evaluation. The standard established, quote, by a positive law to assess the legality of violence, that is to say, its means, can be analyzed only according to its meaning, and therefore the sphere of its use must be criticized with regard to its value. While Benjamin does not go further into detail here on the theme of value, what he says about it here is broadly consistent with the work of another jurist, Leonard Nelson, who in a work entitled Jurisprudence Without Right, Rechtswissenschaft ohne Recht, criticizes legal positivism for conflating the end of law with its value. According to Nelson, whose work Benjamin also knew, positivism thus fails to recognize the value of the non-value that accrues to all that is not correct law, and therefore, according to the legal positivist, cannot be law. We have then two senses of law between natural law and positive law. The one, a self-evidentiary ideal of justice that is universally accessible to all reasonable people, for which any such reasonable person has the duty to struggle. No law or constitution is empirically self-evident in this view. Natural law is inherently revolutionary, though the misconstruals of its potential as raw or biological have diverted it towards cruder dogmas, conflating the ends of law with natural ends. The second sense of law, by contrast, conflates the ends of law with its normative value, its legitimacy, in sole regard to its having been recognized or evaluated as legitimate. Law in one sense is revolutionary, and in the other sense, self-sanctioning. To be legal in the one sense is therefore non-legal in the other. Law as a struggle against the self-evident in the one sense, law of the self-evident as legitimate in the other. Thesis number 3. Law, viewed from the philosophy of its history, is the continuous transformation into non-law and back into law. Though to be legal in one sense is also precisely to be legal in the other sense, inasmuch as both law as struggle against self-evidence and law of the self-evident as legitimate ultimately submit to legal ends for the differentiation between legitimate and illegitimate, and therefore, however hypothetically, to the presence or absence of a general historical recognition of the ends of a legal power in force. The demand raised by positive law for evidence of a historical origin, which remains as the sole criterion for deciding the legitimacy or illegitimacy of means after the criterion of justice has been translated into justness through law itself, specifies power and indeed violence itself, Gewalt, as a function or character of law. Recognized is not merely law, therefore, but Rechtsgewalten, translatable as legal forms of violence. The term dates back to 1514 and denotes power in the sense of Gewalt that has a legal basis, or power on the basis of law. In respect to the history of the concept of the state, Rechtsgewalt stands in contrast to Obrigkeitsgewalt, or power that derives from an authority, such as the head of state. The specification of law as Rechtsgewalt permits a further specification. The ends of natural law, that is, law as struggle against self-evidence, are lacking in historical recognition, whereas the ends of positive law, that is, law of the self-evident as legitimate, have acquired historical recognition. Without historical recognition, the law of the self-evident as legitimate would transform into its ostensible opposite, law as struggle against self-evidence. Without any evidentiary concern for its sovereign decision, therefore, Benjamin isolates historical recognition as the sole meaningful criterion for distinguishing what is or is not law, in the sense of the means that law legitimizes. In other words, legal power or Rechtsgewalt as a formative principle in the philosophy of the history of law. Most of all, not all of Benjamin's examples thereof are suitably ambivalent. Education, for instance, where Benjamin's description of the relevant laws as inhibiting the use of violent means in the pursuit of natural ends also seems to promote corporal punishment. Self-defense, which in modern European law collides with legal ends. The right to strike, which the state endeavors to divert towards fulfilling and perpetuating its own state-sanctioned ends. And of course, the law of war, which tries to a priori sanction victory by means of ceremonially enshrining new law in the peace treaty. Drawing on Max Weber's lecture on politics as vocation, in which Weber articulates the idea that the state enjoys a monopoly on violence. The state enshrines itself as the sole source of the right to use violence. The state can therefore only be described sociologically in terms of its laying sole claim on legitimate physical violence. Benjamin describes the state as feeling everywhere threatened with the positing of new law, and everywhere calling on legal power to preserve its monopoly on violence in the name of preserving law. Law is thus ambivalent in a very specific time-bound sense. Legal power, which is to say legalized forms of violence, deploys in the interest of preserving a monopoly on the use of violence by delegitimizing violence deemed to be used for natural ends, yet sanctioning violence whenever a law-positing character is identified in it. Legal power serves to preserve itself by legitimating means that serve legal power, that is, normative ends. Normative ends, however, are historically recognized ends. Historical recognition grants law its legitimacy. It also marks its historicity and where law must recognize its own end in order to be recognized as law. Put another way, the means that legal power has at its disposal are the very means of its undoing. Legal power traces a topological figure of continuous transformation into its own exteriority. Fate alone, that is to say, the mere idea of a transhistorical and supra-divine principle of causality that links power to the very matters of life and death, binds law to its legitimacy. As Benjamin remarks in the near contemporaneous fragment on capitalism as religion, there is a pagan character, therefore, to law, a self-reinforcing dynamic into which law forces itself into the absence of transcendence. Law, in this sense, is no different from capitalism. For Benjamin, both are non-theological in the sense of they're both producing in themselves the categorical distinctions on which their perpetuation depends. Guilt as debt for the one, guilt as legitimating means of law enforcement for the other. As Georges Sorel writes in Reflections on Violence in respect to the conjunction of capitalism and the non-natural ends of law, quote, economists today are little disposed to believe that the natural laws that impose themselves are due to nature. They see that the capitalist regime came about slowly, but they think that it came into being through a process that should enchant the soul of enlightened man. This brings me to thesis number 4. Law is bound to the fate of capital. Another way to frame the significance of law in its conjunction with the fate of capital is, of course, by way of Benjamin's account of the spectral mixture evidenced in the modern institution of the police. The police represent, as Benjamin says, both violence directed toward legal ends and violence that self-authorizes to set these ends for themselves. Police law, Polizeirecht, and the constitutional state or rule of law, Rechtsstaat, had been bound up with one another since the early history of administrative law. Originally considered a mere instrument of the state, Polizeirecht represented the state's modernity in signaling the means by which good order and felicity could be attained under the prince. With the emergence of the constitutional movement, the police came to be theorized as an independent force situated between state legislation and its everyday delivery to its subjects. In other words, as an aspect of Verwaltung or administration itself, bearing with it, therefore, both Verwaltung's executive sense, in that it implements law as determined by the state, and its creative sense, that is, it remains bound to administrative law, which presents itself as having the juridical capacity to place limitations on the state. This was the achievement of Robert von Moll's Die Polizeiwissenschaft nach den Grundsätzen des Rechtsstaats of 1832-33, in which theory of the independent police force first emerged as part of the very articulation of a Rechtsstaat or rule of law. As a necessarily separate and well-defined force, police law is expressed in and as everyday governance of concrete relations, albeit without containing any legal norms themselves. This dual sense of Polizeirecht as Verwaltung corresponds roughly with what Benjamin says about the police annulling the difference between law positing and law preserving Gewalt. The essential synonymity of police law and administrative law also meant that police force spreads by way of police regulations anywhere there is an identified need for everyday administration, including notably where such need is potentially identifiable, which is to say potentially everywhere. According to the Prussian law of police administration of 1850, which was essentially still governing Germany at the time of Benjamin's writing, police regulations and police orders, their Verordnungen and Verfügungen, act like the uncanny administrative doubles of legal norms without being legal norms per se, with one relating to the prevention of present danger to members of the public and the other oriented towards restrictions on private right in the name of public order and security. For Benjamin, police law therefore detaches its ends altogether from the ends of law, with which they are theoretically identical. Indeed, the law of the police, Benjamin writes, basically denotes the point at which the state, whether from impotence or because of the imminent connections of every legal order, can no longer guarantee through the legal order the empirical ends that it wishes to achieve at any price. Therefore, Benjamin continues, the police intervene for security reasons, quote unquote, in countless cases where no clear legal situation exists. Read, especially where no clear legal situation exists. Aside from generally harassing citizens via ordinances or surveillance, such a shapeless instituting of law thus applies especially to those everyday situations, I contend, where a non-violent resolution of conflict seems to be the most possible. Among all the possible examples of such situations, the example Benjamin gives is of the original impunity of lying. Not, however, as a merely moral or linguistic philosophical matter, but rather as a site in which he specifies that, quote, at a late stage and by a peculiar process of decay, modern legal violence takes it upon itself to penalize fraud as pertaining to financial transactions. Originally, he says, fraud was penalty-free under the principle that, quote, civil law is written for the vigilant, a phrase that can be traced back to a fragment from Quintus Servidius Scævola's Questions Publicly Discussed and preserved in Justinian's Digest. The principle, along with the German proverbial equivalent that Benjamin supplies, Augen für Geld, or eyes for money, they refer to the law that protects the seller against liability for goods that are later discovered to be damaged. The onus would be on the buyer to inspect the goods prior to purchase, after which the buyer bears the risks for defects. Modern law, according to Benjamin, feels the need to intervene and protect the buyer against the ostensible form of violence presented by the fraudulent seller. In other words, modern law's interest lies in protecting the investor and in the circulation and speculation of capital. And law protects the interest of capital as against the potential for violent acts that it imputes onto the reactive capacity of the parties involved. Specifically, Benjamin says, of the defrauded party, which in the context would be the one newly defrauded by new law, that is to say, the seller-producer, the one in whom the use of wholly nonviolent means, here the old law eyes for money, could reactively generate violence. Law fears violence that demonstrates its impotence at the outer or inner edge of law. Law reacts by producing law. Police law represents the ranging of law through these interstitial areas in which the state recognizes its own legal limits, private affairs, empirical transactions. Police law brings capital thereby under its protection, imputing motives for reactive violence onto the characters of those who would endanger the logic of its transactions. Finally, thesis number 5, law is an investment in vulnerable life. In Capitalism as Religion, Benjamin describes the logic of capital as originally pagan, in part because it is perpetuated on the mass destruction of precisely that which originally sustains it, the world condition, which it sees as necessary to inure to a fate of permanent inculpation in order to deliver on the expected gains from its investment, namely an indebting or financialization of the entire universe, so far as that is even conceivable. By its logic, capital has no limits on its range, though its very means of delivering on this investment only intensifies the debt that it expects to collect on. The temporal social sequence by which beings are linked by the fate of capital to one another in a chain of interconnected debts and destinies also appears at the end of Toward the Critique of Violence, where Benjamin discusses the mythic violence that inculpates, then expiates mere natural life, and thereby releases or triggers legal violence. The legend of Niobe illustrates this for Benjamin. Niobe insults the gods and sees her children killed, after which she is turned into, quote, an eternal mute bearer of guilt, qua debt, marking thereby the boundary between humans and gods. Niobe's mourning permanently indexes the establishment of law and its production or perpetuation of guilty because indebted life. Somehow, it is her body and her tears that in the legend are permanentized as indebted life, life that is not extinguished, but turned to stone and a trickle of melted snow, that is, to materiality, according to Sophocles' Antigone and Hölderlin's translation thereof, which Benjamin would have known. Law, accordingly, is not fated to protect capital. Not only fated to protect capital, it produces as structuring principle for our relation to the world and to one another, the debt guilt that capital needs in order to capitalize on life, and does this by transforming life into matter. Matter, that is, moreover, the result of a metamorphosis of sentient and rational life into law by virtue of imputing violent motives onto the beings that are relationally vulnerable. Here, a human mother who loses her children because she has exercised her own reason. Law finds this a productive dynamic to entertain because, like capital, law thereby generates the basis for its own proliferation till it eventually covers the entire surface of the earth with these ambiguous and always permanently and tacitly transgressible boundaries between autonomy and vulnerability, life and matter. Its imputing of natural ends to a life's being lived enables law to vulnerabilize this life and draw it thereby into the sphere of legal power, among other things, but most evidently in the name of protecting capital. And law leaves it to the police authorities, even as it knows that it is insufficient even for the crudest interventions to, quote, range all the more blindly in the most vulnerable areas and against those with any degree of reflection, those from whom the state finds no protection through its law. But here too, as in the example of Niobe, Benjamin specifies that vulnerability is a metamorphosis of life into matter that law invests in, not least in indicating where vulnerability ends, in, quote, those from whom the state finds no protection, those imputed with violent motives, but who in fact are simply, quote, those with any degree of reflection, who, like Niobe, question the very ends of the state and its vulnerabilization of entire areas, into which it then allows police force to range all the more blindly. Much more could be said about this, no doubt, but in the interest of time, let me just conclude with this one thought. Law, for Benjamin, turns out to be an investment in vulnerable life, in life that it transforms into vulnerable matter, by which process law enjoys a return through the production of new guilt and new law. Law is not interested in anything other than intensifying its investment portfolio. Law ultimately protects the interests of capital by investing in vulnerability, but it does so without being able to fully extinguish reflective life, which can be found anywhere, even in those vulnerable areas that police force is adamant about essentializing as vulnerable matter. What Benjamin's thinking on law suggests is therefore this: anywhere there is a vulnerability, the logics of law and capital have intersected to turn life into matter and read the potential for violence and chaos into it. But anywhere there is a vulnerability, there is therefore also precisely the capacity for reflection, a capacity to specify, through mere life, as it were, exactly where capital and legal violence intersect.